If you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge will hear the evidence, the judge will apply the law, the judge will decide whether or not the state proved your guilt. You understand that?
Yes, sir.
I don't know if I said it or not, but as far as a jury trial, you have a jury trial, the verdict in each count has to be unanimous, meaning all 12 have to agree on each, on whether the state proved your guilt. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. It's called cross-examination. The purpose of that is to bring out evidence and help your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel, of course, witnesses to come to court to be able to testify on your behalf, the same as the state. So if you have witnesses you're not certain going to be able to come in voluntarily, then you can request the court to issue a subpoena, which is a court order, and that would then force those people to come to court to be able to testify for you, even though they didn't want to be here, which is the same way the state's witnesses were required to come to court. You understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's your decision, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way from any person at any time in the proceedings. In fact, no one's even allowed to talk about it except in one situation, and that is, if there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. And that must be done by proof beyond reasonable doubt. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to put on any defense. You may, but you're not required to. Whether you do or not, the state of Ohio will have the burden to prove you're guilty on each essential element of each offense by proof beyond reasonable doubt, which is the highest burden that's known under the law. You understand that?
Yes.
Right now, originally you entered a plea not guilty to these charges. That denied the allegation in the indictment. Actually, I think you also entered not guilty to consent. And the plea denied, the not guilty pleas denied the allegations, denied you committed a crime, and exercised all the rights I just described. Now, if you change your plea from not guilty to guilty, that's the complete opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits their crime, admits that you're the one who committed that crime. And that plea, waives gives up all of the rights I've just described for you here today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. Without exception, your plea of guilty. Waives gives up the right to have a jury or court trial. Waives gives up the right to confront the witness against you and cross-examine through your attorney. Waives gives up the right to use the power of the court to compel a forced witness to be in court to testify for you, the same as the state. Waive gives up your privilege against self-incrimination because if you say you're guilty, that's what she finds you guilty. The waive gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives gives up a right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence, you could file an appeal, and there are also other limited circumstances where that can be done. Any appeal that you want to file will have to be filed within 30 days of your sentencing after being filed. And then a plea guilty also subjects you to being sentenced immediately by the court, which is like what's likely to happen here today if you plead guilty. Now, you understand all those things I just said?
Yes.
Are you a U.S. citizen, Mr. Green?
Yes.
And you're entering into this guilty plea agreement voluntarily?
Yes.
You have any questions about the charges and possible penalties?
Yes, sir.
You understand?
Yes.
Any questions about the plea of guilty? I'm sorry, about the plea agreement itself?
Yes, sir.
You understand it?
Yes, sir.
Again, you understand the recommendation of sentencing and the decision on judicial release are not binding on the court when it comes to the court making those decisions.
Yes, sir.
Have any questions about the constitutional rights I've explained?
Yes, sir.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
All right, now, you have any concerns you'd like to speak to Ms. Hackner about before we go any further?
No, sir. Yes, sir.
You have any questions about anything I've explained to you here today?
No, sir.
Is it your decision, Mr. Green, to withdraw your not guilty pleas, counts 1 to 3, and enter pleas of guilty thereto, according to the terms of the written plea agreement we've just gone through?
Yes, sir.
All right, then, as to the charge in count 1, it alleges that on or about March 15, 2021, in Highland County, Ohio, you did cause or attempt to cause physical harm to Patrolman J. Beatty by means of a deadly weapon or dangerous ordinance to win a 2017 Dodge van, and that you knew, other than that Patrolman J. Beatty was a police officer as defined in ORC 2935.01, violation of section 2903.11A2, the charge of malicious assault of a peace officer, first degree felony carrying possible minimum sentence set by the judge of between 3 and 11 years, and a maximum of up to half of that added on, which means a maximum of 16 and a half years. How do you plead?
Guilty.
Then as to count 3, which alleges that on or about March 15, 2021, Highland County, Ohio, you did receive, retain, or dispose of certain property being motor vehicles defined in ORC section 4501.01, property of another Kristen Smith, and that you knew or had reasonable cause to believe that property had been obtained from the commission of theft offense in violation of section 2913.51 of the Ohio Revised Code. The charge of receiving stolen property, fourth degree felony, possible prison term between 6 and 18 months. Also a fine of $5,000. How do you plead?
Guilty.
All right, the court finds then on this day, no court defendants violate all constitutional rights made a joint tell voluntary waiver of the same percent criminal 11. Please accept the court file. And is found guilty of counts 1 and 3 as set forth in the plea agreement. As set forth in the indictment. Count 1 being first degree felony, count 3 being fourth degree felony, count 2 is dismissed. Now, given the nature of the offense in count 1, and there's not a request for a pre-sentence report, and the court knows a lot about Mr. Green since there's been all these reports filed and so forth. Their dependency in this case is, well, his past history is in the discovery, so not going to order a pre-sentence report. We'll go ahead and proceed with sentencing forthwith. Mr. King, on behalf of the state.
Only one place contained in the plea agreement, Your Honor.
All right, Ms. Hackner.
Thank you, Your Honor. Your Honor, Brandon has come a long way. So it's been almost a year since this event occurred, and he's been held in custody continuously since that time. And there's very little doubt in my mind that at the time of the occurrence, he first came into custody, he was suffering from a very deep drug dependency. I think this last year in custody probably has saved his life. He's been, he's got to keep because there's been no choice. We've chatted and he has told me he feels better than he's felt in probably a decade. He looks better than I've seen him look in a very long time. And I think that it's obvious that's because he's not actively using drugs anymore. My concern for him for the future is having the skills to remain off the drugs and learning the skills to be able to say no. And that's why I believe that this resolution is good for him, especially if he is released to start, so that that will teach him the skills that he needs to stay away from the drugs. So we ask that you follow the plea agreement, and I understand that the question of this release is not right, but we would ask that you follow the agreement that we have made.
All right, Mr. Green, is there anything you'd like to say?
I'd like to apologize for my character before the day, and instead of stand on that day, if I haven't find a lot of choices that I make in my life, I wouldn't be here, but thank God that, we're not dead and nothing bad or worse happened that day. Never my intention to smear the court, and I'd like to apologize to the court before and my conduct when I tried to fire the court. I was just deluded in my mind, but like Catherine said, I'm very clean, and I just want to be a productive member of society, and I just intend on trying to do that.
All right. Well, I'll have to agree that what Ms. Hacker said is accurate. Is you do look and sound much better than you have for quite a while. In the time of waiting for all these mental exams and then the treatment, as well as going through the processes we've gone through, you sound much better. So I think that to that extent, the time has been beneficial to you. And you've taken responsibility for this. Of course, count one is a very serious offense, first degree felony, and it's against a police officer. So, you know, that is a serious matter. I'm sure that there's no doubt, I think you read the information in the file that, and in the reports that were done, that, you know, you were suffering from the effects of your addiction at the time. So the court is going to follow the recommendation in the plea agreement as to the sentence. And it's ordered that you be in our hereby sentenced to the Correction Reception Center in Ohio for a period, on count one, for a minimum period of 4 years. And that could be a maximum period of up to 6 years as decided by the Department of Rehabilitation Correction under the Oregon Code Law. On count three, you were sentenced to a term of 11 months. The court will order those sentences to be served consecutively to one another as based upon the recommendation of the parties. The court finds that they're two separate courses of conduct. I believe the vehicle that was taken was the one that was used as assault officer. But one, so they're separate offenses, and although connected, they have different victims. And one single sentence will not adequately reflect the seriousness of the offense, and the penalties that be imposed are not disproportionate to the seriousness of the crime. And also, the court finds that the history of criminal conduct justifies these sentences. Now, according to the court, you were arrested on March 17th of 2021. Is that correct?
Yes.
All right. So that would be a total then of 351 days of jail time credit. This is the third, 14 days shy of the year. Now, upon completion of this prison term, the law provides that you will be placed on mandatory post-release control supervision as a count one for at least 2 years, up to 5 years, as determined by the adult parole authority. And optional on count two, so up to 2 years, but we know that you're going to be on count one. Now, that means that you'll be supervised in the terms that they set, and after that period of time they determine that you have failed to comply. They can return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term that's imposed for all violations. However, if you committed a felony while under post-release control supervision, then in addition, whatever sentence the judge had would impose upon you, that judge would also sentence you for committing that offense while under post-release control. In this case, to an additional period of 1 year or whatever time left on that post-release control, whichever is greater. If that occurs, that must be served consecutively with the sentence in the case. You're also ordered to pay the court costs for judge to grant execution order. If you fail to do that, that can be collected by the clerk. The judge needs to put the letter in bank accounts where the mortgage or other assets you may have. If that doesn't collect it, then good to community service once you are released from prison. In this county, you can give a credit for each hour you work in an honorary assigned by the court. Each hour you work, produce your judgment by that amount to a patient court. And if I didn't say it before, count two is dismissed. All right, is there anything further from counsel?
Just restitution, Your Honor.
Oh, that's right. $1,000 of restitution is ordered to be paid to the Greenville Police Department. $500 to Kristen Smith, as agreed in the plea agreement. And those payments will be made through the victim escrow account at the victim witness office, and then pay any fees that are associated with that. That is a substantive or substantive sentence, so it can't be discharged from bankruptcy. Mr. Green, and will follow you the rest of your life until it's paid. All right, now anything further?
Here.
All right, thank you. All right, Jeremy Woolridge. Okay, Mr. Woolridge, you'll need to unmute yourself. There's a button down there toward the bottom that says unmute. You got it.
Can you hear me?
Yep, I can hear you. All right. Case number.
1 minute, sir. We're good.
All right, this case number 19 CR 169, State of Ohio versus Jeremy R. Woolridge. And you're Jeremy Woolridge, right there on the screen mark, Jeremy Woolridge.
Yes, Your Honor.
All right, this is a hearing set for sentencing, being conducted by Zoom. Mr. Woolridge is appearing from his phone. His attorney is Sarah Barker, appearing by Zoom from her office, and from his office, Assistant Prosecutor King. Mr. Woolridge entered plea guilty to aggravated possession of methamphetamine. The matter was set for sentencing today. Now, I have to say, Mr. Woolridge, I'm a little surprised that you're here, but I guess it's because we're on Zoom, because according to what I received from the prosecutor's office, I'm sorry, from the probation department, you have not reported them since January the 13th, and last contact was January the 20th, and then you failed to come in, failed to reschedule. They tried numerous times to reach you. All of your no numbers will not work. And so I'm going to continue this hearing in order you to appear before the court in person. And I'm going to order you to report to probation by 4 p.m. tomorrow. And if you fail to do that, you will, and they notify, well, actually, I'm going to say by 3, but they close at 4, and if you're not there by 3, and they notify the court, then the court will issue a capias for your arrest, and you'll be picked up. This case will be continued until see, next Thursday is the 10th. You're available on Thursday, right, Ms. Margaret?
I have a doctor's appointment at 1:30.
Is that local or out of town?
It's local.
Well, we can do it at 11 a.m. if that's better for you.
That's fine.
All right, at 11 a.m. So, if you report to probation, whether you report to probation or not, you better be here then. But if you don't report to probation, I'll have a warrant issued for you. And if they find you over the weekend, then you'll spend that time in jail till we have this hearing. It's not a real good sign when you can't even report before your sentence. So, right now you're really on thin ice, so you need to get to the probation department and by 3 o'clock tomorrow, and then get in touch with your attorney, let her know what's going on, and then make sure you're here next week. If you don't appear either of those times, like I said, we'll have a warrant issued for you. All right?
Your Honor,
Yes.
Thank you.
I apologize, but if it would be possible, I need Mr. Woolridge's number because he hasn't had any contact with me either, and the phone numbers that I have are not working.
Okay. Give her your phone number, Mr. Woolridge.
No, it's my mom's phone number, but it's 708-1073.
Are you living with her?
Now,
Pardon me?
I don't have a phone right now, but I'm using my mom's.
Are you living with your mother or somewhere else?
Both places.
All right, well, you need to keep probation informed of that, because remember, you're also under house arrest, so you better be compliant with that, because that's another thing that, I'll look at when it comes time for the sentence. All right, well, you can go ahead and sign off, Mr. Woolridge, thank you.
Did Sarah get his number?
Huh?
I don't think Sarah got his number.
All right, anybody else on the jail? We're done with jail.
We have 2 more. He was at Zoom, and we have 2 more Zooms.
I know we have one, okay.
Sparks and Owens, none at the jail.
Who?
Sparks and Owens, but none at the jail.
Sparks is not in here. Okay, what's your name there, sir, that's at the probation department? All right, Mr. Sparks, would you unmute the computer?
Yeah, thank you.
There you go, you did, thank you.
Thank you.
Case number 22-CR-23, State of Ohio versus Gary Sparks. Present for the state is Assistant Prosecutor King. Present for the defendant is Attorney Sarah Varga. And again, for the record, here, Gary Sparks appearing from the Probation Department on the screen mark HCPD.
Yes.
Yes. All right, this hearing is being conducted by Zoom. Ms. Barker, do you and your client both stipulate that the hearing can be conducted remotely rather than in person? Did you hear me, Ms. Barker?
Yes, Your Honor.
Okay.
Sorry, my mic didn't pick it up.
Okay. All right. And you're okay with that as well, Mr. Sparks?
Yes.
All right. Now, Mr. Sparks is charged, I think he's just charged in 2 counts. Counts 27 and 28, versus 33 counts total involving 6 defendants. He's charged in 27 and 28. Now, I've been presented with a plea of guilty form, Mr. Sparks, which indicates you're going to plead guilty to count 27, committing drug abuse and 5th-degree felony. This form has been prepared by the prosecutor's office, and I'll hold the first page up to the camera for you to see that this is the form we're looking at. Has your name, case number on it. You see that? It says plea of guilty and charge.
Yes.
On page 3, there are signature lines, and there's a statement just about halfway down the page. It says, I entered this plea voluntarily. Right below that appears to be the signature of Gary Sparks dated today. I'll put that up to the screen as well. Is that your signature that I'm looking at?
Yes.
And I assume you signed that earlier today when you met with Ms. Carter?
Yes.
Did she go over this with you and explain it all to you and answer any questions you had?
Yes.
You understood it was agreement to plead guilty to count 27, which means it won't be a trial. The next step in your case will be a sentencing hearing.
Yes.
And do you have enough time to fully consider this matter before making this decision?
Yes.
Do you feel that you were pressured or rushed in any way in doing this?
No.
You're entering into the agreement to plead guilty voluntarily.
Yes.
Now, the agreement states on page 1 that you're going to, as I said earlier, plead guilty to count 27 for drug abuse, a 5th-degree felony in violation of section 2925.13b of the revised code. It states that you understand that the maximum penalty for that could be 12 months imprisonment. There's a minimum of 6 if prison imposed. There's a fine of $2,500 and a possible license suspension of 6 months and 5 years. Do you understand that?
Yes.
Now, are you facing any felony charges in any other jurisdiction? And are you currently on probation, community control, parole, or post-release control from any jurisdiction for a felony?
No.
All right, now under the law, if you are convicted of this offense and serve a prison term, once you complete that term, the sentence includes the possibility that the adult parole authority would exercise their option under the law to place you under post-release control supervision for a period of up to 2 years. They don't have to do it, but they can. The decision is up to them, of course, not involved with that. If they do, you supervised by a parole officer on the terms they set for a period again of up to 2 years. If they determine during that period of time that you failed to comply, then they could return you to prison even though you served the entire prison term set by the court for an additional period up to, in this case, half of your prison term for 1 or more violations. However, if your violation is a felony, if you commit a felony while under post-release control, then an additional sentence to be imposed on you in the new case, the judge in that case can also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that 3 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively sentence in the new case. You understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose community control, which means that same thing as probation. It means instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on the term set by the court. If during that period of time probation felt you were not compliant, they would notify the court, write a certain copy of that notice on you. You'd be entitled to have a hearing, be represented by counsel, and the outcome of that, unless you failed to comply, then at that time, the court would revoke the community control and sentence you to prison for 6 to 12 months, fine $2,500. You understand that?
Yes.
All right, now, the charge in count 27 alleges that on or about June 23, 2021 in Huntington County, Ohio, you and Kathy A. Sparks did being the owners or lessees or occupants of persons in control, custody, or supervision of premises located at 820 Mirabeau Street in Greenville, Huntington County, knowingly permitted the premises or real estate to be used for commission of felony drug offense to wit, aggravated trafficking of methamphetamine and aggravated possession of methamphetamine by another person to wit, Jennifer R. Ison, in violation of section 29.5.13b. So that's the charge of committing drug abuse and certificate recovery. Now, you understand what it is you're charged with, what the state says you did, when, where, how, they let you did it.
Yes.
All right, back here. I set this, all right, sorry about that. Now, so you understand what it is the state accused you of having done, when or how they alleged you did it.
Yes.
And you understand the possible penalties for that offense.
Okay.
You understand the possible penalties for that offense.
Oh, yes.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you try to raise in trial, the possible outcomes of the trial with your attorney?
Yes.
And are you satisfied with her advice and confidence in this matter?
Yes.
Are you under the influence of any type of drugs or alcohol at this time, Mr. Sparks?
No.
Are you taking any prescription drugs for any reason?
No.
Has anyone threatened you to make you plead guilty here today? Now, at the bottom of the page 2, there are 3 sentences printed in bold and underlined, and I'll read those at this point, this time. Defendant shall enter plea of guilty to count 27, state will dismiss count 28, state defense jointly recommend community control based on HB 86. Defendant agrees to cooperate fully in prosecution of all co-defendants. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today? All right, now, under the law, the matter of sentence is up to the court, not to the parties. So even though there's an agreement that you should be getting community control, once I hear all of the information that is presented, if I decide that's not the correct sentence, I could sentence you to prison for between 6 to 12 months, finding $2,500. You understand that?
Yes.
Now, do you hold any license or certification from any state governmental agency regarding any that regulates any occupation or profession?
No.
Right, now you have constitutional rights, must understand, before I can accept a plea of guilty from you. First, you have the right to have counsel. Barker was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you would like to provide. So, if you decide that you do not want to plead guilty, that you want to defend against this charge, or 2 charges actually, then she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes.
Right now, under the Constitution, you have the right to have a jury trial on this matter, in which 12 people will be selected from a group of citizens who reside in this county, summons for jury duty on your trial day. After they were selected, the evidence will be presented, they'd be instructed on the law, and then that jury would have to decide by unanimous verdict, which all 12 have agreed, whether the state troops are guilty. You didn't want to have a jury trial, but you didn't want to plead guilty. You can waive in writing, which means to give up, your right to have a jury trial in this case, and then you would have what's called a court or bench trial, meaning it would be the judge who would hear the evidence, the judge would apply the law, and the judge would be the one who would decide whether or not the state troops are guilty, by proof beyond reasonable doubt. You understand that?
Yes.
Now, under the Constitution, you have a right to confront the witness against you and cross-examine through your attorney. That means, and that would have to be in the court. So what that means is that the witness against you have to come into the courtroom and testify in front of you and your attorney and the president. After the prosecutor done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence to help your side of the case. You understand that?
Yes.
Under the Constitution, you have a right to use the power of this court, Mr. Spark, to compel courts to come into court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, you request court orders called subpoena. That would force those witnesses to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes.
All right, now, under the Constitution, you have the privilege of self-determination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision and decide not to testify. The fact that you did not testify cannot be used against you in any way by any person. No one's even not comment about it, except in one situation, that is if there's a jury trial and you want to testify, the judge instructs the jury that because that is right, they cannot consider it for any purpose. Do you understand that?
Yes.
Under the Constitution, you're presumed innocent of this charge. You'll prove guilty by the state of Ohio on every essential element of the offense charged. What that means is that you cannot be forced to give evidence at any time in the case. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. Decide you're not going to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about it except in one situation, which is if there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state on every essential element of the offense charge. So you are not required to try to prove you're not guilty. The state's required to prove you are, and they have to do that by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally, you entered a plea of not guilty. That plea denied the allegation in the indictment, denied you committed a crime, and exercised or revoked all the rights I just described. You change your plea from not guilty to guilty, that's the opposite of not guilty. Guilty plea admits the allegations in count 27 that there are crimes that you committed that crime. If that plea waives gives up all the rights that I just described for you here today, except the right to have counsel, which will always happen no matter what you plead. With that exception, your plea of guilty waives gives up the right to a jury court trial. Wage gives up your right to confront witnesses against you and cross-examine for your attorney. Wage gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you the same as the state. Wage gives up your privilege against self-incrimination because if you say you're guilty, that's what you find guilty. Wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you guilty. It also, wage gives up that right to file an appeal that you think you may have had up to this point in the case, unless I sent you the maximum sentence or under the other circumstances, in which case you could file an appeal, and that would have to be filed for 30 days for sentencing to be filed. And finally, it does objection being sent to me by the court if the court feels that that is the appropriate thing to do. You understand all of that?
Yes.
And Mr. Sparks, you are a U.S. citizen?
Yes.
Do you have any questions now about the charges and possible penalties?
No.
You understand them?
Yes.
Any questions about the plea agreement?
No.
You understand it?
Yes.
Have any questions about the constitutional rights I've explained to you?
No.
You understand those?
Yes.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand it?
Yes.
Is there anything you need to speak with Ms. Barber about before we go?
No.
Then is it, and you have any questions about anything that I've explained here today?
No.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge set forth in count 27 as we have just discussed?
No.
It is. You're going to plead guilty?
Yes.
Okay. All right, then as to the charge in count 27, which reads that on or about June 23, 2021 in Highland County, Ohio, you and Kathy A. Sparks did being the owners or lessees or occupants or the person's control, custody, and supervision of the premises located at 820 Mirabeau Street in Greenville, Highland County, Ohio, knowingly permitted the premises or real estate to be used for the commission of felony drug offense to wit aggravated trafficking of methamphetamine and aggravated possession of methamphetamine by another person to wit Jennifer R. Eisen in violation of section 2925.13b of the Ohio Revised Code, charge of permitting drug abuse, a fifth-degree felony, carrying possible prison term between 6 to 12 months and fine $2,500. Please. All right, now the court finds that on this date of the court, defendant was provided all his constitutional rights, made an intelligent voluntary waiver statement of criminal 11 pleas except for filed and found good in count 27 fifth-degree felony charge therein. Count 28 is dismissed. Court refers the matter for a pre-sentence investigation. Sentencing will be set, sentencing bond will be continued, and sentencing will be set for April 7, 2022 at 1 p.m. That's a Thursday afternoon, Ms. Barber. All right. Mr. Arzuman is he's at the probation department, so you'll take care of it then. Anything further from counsel?
No, Your Honor.
All right. Thank you. All right, Mr. Owens there on the K family site.
Yes, Your Honor.
All right, thank you for being patient. We've had a lot of cases this afternoon that have ended up being longer than we thought they would. All right.
I understand.
Case number 22 CR. Oh, no. All right, case number 22 CR 00 versus Christopher R. Owens. Mr. Owens is appearing on the screen for K family. Is that correct, Mr. Owens?
Yes, sir.
And where is it you are? I forgot.
Okay.
Where are you?
At home.
You're at home. Okay, you're not at home. Okay, that's not a family. Okay, family. I thought it might be a treatment facility. Okay. All right. This hearing being conducted by Zoom. His attorney is Sarah Barber, appearing by Zoom, and also appearing on behalf of the state, Assistant Prosecutor King, by Zoom. And this Barber, you and your client both agreed to have this matter conducted remotely by Zoom rather than an in-person appearance before the court.
Yes, Your Honor.
And you're all right with that as well, Mr. Owens?
Yes, sir.
All right. Mr. Owens is currently charged with 2 co-defendants in case number 22 CR 32, just like in count 7 and 8 and 15 and 16. Counts of aggravated trafficking of methamphetamine and 2 counts of aggravated possession. Now, I have been presented with a plea of guilty for Mr. Owens in this case, and then also note for the record that there was another indictment returned against Mr. Owens in case number 22 CR 50 on March the 1st. He's not been served with that, but I have here an entry of dismissal. So that's going to be dismissed if there's a plea in this case. Is that correct, Mr. King?
That's correct, Your Honor.
All right. And you're obviously aware of that, Ms. Barber, since it's in the plea agreement. Okay. All right. Now, Mr. Owens, I'm going to hold this up to your to the screen, and it has your name and case number and plea guilty form, and ask you if you would recognize that.
Yes.
Okay. And on page 3, there are signature lines, and just not quite halfway down the page, there's a sentence that says, "I enter this plea voluntarily." It looks like the signature of Chris Owens, 3322. I'll hold that up to the camera as well. And is that your signature next to my finger there that you're looking at?
Yes, sir.
And it says you dated it, so you just signed it earlier today.
Yes, sir.
And you were with Miss Barber when you signed it.
Yes, sir.
And did she explain the agreement to you and answer any questions for you?
Yes, sir.
And when you signed it, did you understand that's an agreement to plead guilty, which means there won't be a trial, and next step in your case will be a sentencing hearing?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, sir.
And do you feel that you've been pressured in any way in doing this?
No, sir.
And you're entering into this plea agreement voluntarily?
Yes, sir.
Right now, the agreement states on page 1 that you're going to plead guilty to count 2 of the indictment. He's not charged with count 2.
Just make count 7.
Oh, okay, I'm sorry. Sorry, I looked at it through the wrong field of my bifocals. It looked like a 2. All right, count 7, which is aggravated trafficking of methamphetamine under 2925.03A1 and third-degree felony. It further states that you understand that the maximum possible prison term for this is 36 months. The minimum prison term for those is 9 months. There could be a fine of up to $10,000. There's a mandatory fine of $5,000 and a possible license suspension of 6 months to 5 years. Prison term is presumed to be appropriate, but is not required. You understand that, Mr. Owens?
Yes, sir.
All right, now, are you currently facing any charges in any other jurisdiction?
No.
And are you currently on community control, probation, parole, post-release control for a felony in any jurisdiction?
No, sir.
Right now, under the law, if you are convicted of this offense and serve a prison term, once that term is completed, the adult parole authority could decide at their option to place you under what's called post-release control for a period of up to 2 years, which means you'd be supervised under the terms they set by a parole officer, and if during that period of time they felt that you had failed to comply, they could return you to prison, even though you served the entire term ordered by the court for an additional period of up to 9 months for one violation, up to a maximum of half of whatever prison term that was imposed by the court. Now, in the event that you were convicted of a felony on post-release control, then in addition to whatever sentence the judge in that new felony case imposed upon you, that judge could also sentence you in this case for committing that offense while under post-release control to an additional period of 1 year, whatever time is left on the post-release control term, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes, sir.
All right, now under the law, I'm not mandated to sentence you to prison for this offense, even though it's presumed. So I could, instead of sentencing you to prison, be between control or probation. That means you would go to prison, but instead would be supervised for a period of up to 5 years by a probation officer in the term set by the court. And after that period of time, the probation department felt that you were not complying, they would have to file written notice of that to the court, provide a copy of that to you. You would be provided a hearing and be entitled to have an attorney. And if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and sentence you to prison for 36 months and fine you $10,000. You understand that?
Yes, sir.
All right, now, the charge in count 7 alleges that on or about March 10, 2021 in this county, Caleb R. Leonard and you did knowingly sell or sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding bulk amount, less than 5 times bulk amount, violation of Section 4925.0381, which is a charge of aggravated trafficking methamphetamine, third-degree felony. And again, carries possible penalties of between 9 and 36 months in prison with certain increments provided by law. Fine of up to $10,000, mandatory fine of $5,000, possible life suspension 6 months to 5 years. Now, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor. I'm not aware of that degree. They said I would be signed up to go for the F4 and F5.
I don't know what you're talking about.
Your Honor, I went over the plea with him in detail already once. Chris, it's an F3. We went over that today.
All right.
We also went over it the other day when we met, I think last week.
Yeah.
You're charged in count 15 with an F4, count 16 with an F5, but you're charged with another F3 and 8, and the plea is to count 7, and that's a third-degree felony, like your attorney said.
Okay.
Now, do you wish to go ahead and go forward, or do you want to not go forward here today and talk to your attorney before we continue this? You don't have to go through with this if you want to, wait and talk to your attorney. I can even let you and her talk about this in the breakout room and take another case. Well, actually, I don't have a prosecutor here.
We can go ahead and continue.
Okay. So you want to go ahead and continue to plead guilty to the charge, which is a third-degree felony, as I just explained.
Yes, sir.
Okay. So now we've explained it to you. You do understand the penalty for the offense.
Yes, sir.
All right. And we discussed the nature of this charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, possible outcomes of the trial with your attorney.
Yes, sir.
Are you satisfied with their advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, at the bottom of the page, there's 4 sentences that's printed in bold, and there's also been additional sentence added in ink, and I'll read that as follows. Defendant shall enter plea guilty to count 7, state dismissed counts 8, 15, and 16. State defense joint to recommend 24 months incarceration. Defendant shall pay restitution in the amount of $200, 140 joint several with letter, and $60 alone. Defendant shall cooperate fully against co-defendants. And then in ink, state will dismiss case 22 CR 50, which is a new indictment, which is another 53 felony. Now, is that your understanding of the agreement, Mr. Owens?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, the recommendation as to the sentence is not binding on the judge, because the court is the one that has that authority. So, even though there's a recommendation that the sentence should be 24 months, if you plead guilty, they could decide to sentence you to any sentence I think is appropriate between 9 and 36 months under the increments provided in the statute, and impose a fine of $10,000 and suspend your license for 6 months and 5 years. You understand all that?
Yes, sir.
Now, do you hold any type of license or certification from the state of Ohio for any occupation or profession?
Yes, sir.
And you have rights to misunderstand before I can accept your guilty plea. First of all, you have right to counsel. Ms. Barber was appointed to represent you, not simply to work the case out, but provide any defense that could be available to you under the law that you provide. So, if you do not want to plead guilty, you want to fight these charges, and she'll continue to represent you to do that, including any trial if that's what you want. You understand that?
Yes, sir.
Right, under the Constitution, you have the right to have a jury trial in this matter. Mr. Owens, 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented. The judge will instruct them on the law, and they will decide by unanimous verdict on 12 of them after agreed on whether the state agrees to go. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing. That means you give up the right to have a jury trial. And in that case, you have what's called a court bench trial, meaning the judge will be the one to hear the evidence instead of the jury. The judge will apply the law, and the judge will decide whether or not the state proves to be up by proof beyond that. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you in open court and have your attorney cross-examine. What that means is witnesses against you have to come in open court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to compel or force witnesses to come to court to testify for you in the state of the state. So, if you have witnesses you're not certain going to come in voluntarily, jury request for you should court orders called subpoena. That forces those witnesses to come to court to be able to testify, even though they don't want to be here, which is the same way the state witnesses are required to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, Mr. Owens, you have the privilege against self-determination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way, by any person, at any time. In fact, no one's even allowed to talk about it except in one situation, and that is if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that? You understand that?
Yes, sir.
Okay. Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're unguilty. The burden is upon the state to prove that you are guilty. And in fact, you don't even have to present any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof is upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right. Now, originally, you entered a plea of not guilty to this charge. Not guilty plea denied the allegation, denied that you had committed any crime, and it exercised or invoked all the rights I've just described. You change your plea of not guilty to guilty, that is the opposite of not guilty. The guilty plea will fit the allegations in the indictment, admit that there are crimes that you're the one who committed that crime. And that plea will waive and give up all of the rights that I just described for you, except the right to have an attorney. You always have a right to have an attorney, no matter what your plea. With that exception, your plea of guilty will waive and give up the right to have a jury or court trial, it will waive and give up the right to use confront witnesses against you and cross-examine for your attorney. It will waive and give up your right to use the power of the court, compel or force witnesses to come to court, testify on your behalf to stand to state. It will waive and give up your right or your privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. You waive and give up your presumption of innocence because if you say you're guilty, that's what you find you guilty. It also waives and gives up your right to file an appeal on any alleged violations of your rights you feel you may have had up to this point in the case. Now, in the event that I sentence you the maximum sentence under the certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all that? You understand all that?
Yes, sir.
Okay. You need to speak up because I'm having trouble hearing you.
Yes, sir.
All right, thank you. All right, and also subject you to being sentenced immediately by the court. I didn't say that earlier. You understand that?
Yes.
Okay. All right, now, do you have any questions about the charge and possible penalties, Mr. Owen?
No, sir.
You understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Do you understand the recommendation on sentencing not binding on the court?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand it?
Yes, sir.
Is there anything you'd like to speak to Ms. Barber about before we go any further?
No, sir.
Have any questions at all about anything that I've explained to you here today?
No, sir.
This is your decision then, Mr. Owens, to withdraw your not guilty plea legal to count 7 of the indictment pursuant to the terms of the written agreement we just went over.
Yes, sir.
All right, and as to the charge in count 7, which alleges that on or about March 10, 2021, in Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount, violation section 2925.03A1 Ohio Revised Code, the charge of aggravated trafficking in methamphetamine, a third-degree felony, preparing possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and possible license suspension of 6 months to 5 years. How do you plead, Mr. Ellis?
Guilty.
All right. Court finds that on this day, an open court, defendant was advised of all constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Please accept and order filed. Defendant is found guilty of count 7, aggravated trafficking in methamphetamine is charged therein, a third-degree felony. Counts 8, 15, and 16 are dismissed. Since Mr. Owens is not actually present in the courtroom here today, no request for a pre-sentence investigation. I'm going to go ahead and set this for a clear person before the court. And I think we just set one for next Thursday at 11, so we'll set this one at 11:15. That would be March 10th. So if you're here, an important person next Thursday, Mr. Ellis, and be prepared to be transferred to the institution if that most likely will happen. All right.
Yes, sir.
Anything further, counsel? All right. Thank you. All right, we'll take a break here. Mr. King, are you coming over to cover these other two areas first? Okay. All right. We'll see you in a few minutes. Thank you. Right.
Please rise.
Page number 20 CR 265, State of Ohio, Eric Paul Tabor, for the state, is prosecutor Kane, Officer Kelly, the base for Defendant is Wagner. Are you Eric Paul Tabor?
Yes, sir.
Right, Mr. Tabor was placed on community control for aggravated possession of a fentanyl-related compound, fifth degree felony, on June the 7th last year. On February 8th, there was a notification filed that the defendant had failed to comply. The court advised the defendant of those allegations, and the matter was appointed counsel to Mr. Wagner, and then set the matter for hearing today. Mr. Wagner, he had the opportunity to review these allegations with your client.
We have, sir.
And do you wish to have a hearing, or we go to permission?
We would, sir.
Right. Mr. Tabor, you have a right to have a hearing on this matter, in which the state will be required to present evidence to prove to the court that you have failed to comply. You have a right to have your attorney cross-examine the witnesses the state presents. You have a right to present testimony, evidence in your own defense. Now, in the event that it's found that you have failed to comply with these conditions, one of three things can happen. I can continue community control as before. I can continue with the additional conditions I think are appropriate. Or the third, the most serious, is that I could revoke community control, send you to prison, 12 months, and fine you $2,500. You understand that?
Yes, sir.
And has anyone promised you anything to get you to plead guilty here today?
No, sir.
Has anyone threatened you in any way to get you to plead guilty here today?
No.
The allegations that were filed against you allege you violated Rule 2 in that you have failed to report to the probation department and directed over 14 times in the last year and sets forth the dates. Rule 7 alleges you tested positive on 6/3/21 for marijuana, buprenorphine, and kratom. Is that 6/3? I think it was on, I have my notes on, yeah, he's on community control on 6/7. So that would not be a violation of this control. So that was stricken out. The thing about the that said it did provide a prescription for those about prescription on 6/3. But for the buprenorphine. But the remaining part of that would not be appropriate. But then it says 10/26, test positive for marijuana, benzodiazepine, methamphetamine, and amphetamine. Then it used advised purchased illegal substances from someone at work, and then on 10/30, 21 tested positive for marijuana, buprenorphine. Rule 15, then we still owe court costs $321.50, and there had been a payment plan set up a couple of different times. Looks like not back. So those were filed by an officer. Now, you understand the allegations, Mr. Tabor?
Yes, I do, Your Honor.
You understand your right for hearing?
Yes.
All right. You understand the consequences that can happen if you miss here today?
Yes, I do.
Right. Then you admit to the allegations with the exception of the Rule 3rd, 21 allegation and Rule 7 violation.
Yes.
All right. Anything from the state or the probation department regarding this position?
Yes, Your Honor. Given that this is the defendant's first community control violation, the state and probation department would ask that he be continued on community control and also ordered to complete treatment at the counseling center, and there is a bed available for him there on Monday.
All right, Mr. Wagner.
We would ask the court to follow the recommendation. I've met with Eric, actually Mr. Eric from our original actually like Eric, he doesn't give me too many excuses. It's very straightforward. He indicated, I think it is true, I think he does work. One of his problems is he's messed up the priorities a little bit here, Your Honor, and working and putting probation behind him. I advise him he doesn't put that around, the court will take care of that, and if it's in prison, we won't have to worry about work. He understands that, Your Honor. I believe he's indicated he may have paid off some of the fines and court costs, if not, he had a payment to make today.
Yes.
So he just needs to, he's towing the line, he just needs to get in line, from the last stop. That's all, sir.
Tabor, anything you'd like to say?
I would like to formally apologize to the probation department for not taking it more seriously. I really don't have an excuse for it, except for the fact that I should put you in their head and the rest of it. So I do apologize. And I'm willing to do so from now on, if given the chance. That's all.
All right, I'll be the order of the court, then that your control be continued. And there are additional conditions. You're to successfully complete the substance use disorder treatment at the counseling center and any recommended aftercare. And you'll be committed to jail until you go to the counseling center, which will be Monday the 7th. You come to jail forthwith. And you did the court. All right. Anything further, counsel? All right. Any questions? Jason, part 9. Is case number 21CR150, Dave Ohio versus Jason Carnine, President of the State's Assistant Prosecutor King, President of the Defendant's Attorney Lori Colby, and you are Jason Carnine.
Yes, sir.
All right. Is it Carnine or Carnine? Carnine. Carnine. Mr. Carnine has pleaded guilty to aggravated possession of methamphetamine, 5th-degree felony. The matter was referred to the probation department for a pre-sentence investigation. The court has received that, and each of the attorneys received a summary.
Stay guys.
Yes, Brian.
All right, Mr. Name of the head of state.
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. In looking at the defendant's criminal history, it appears that he has 9 prior felony convictions, including conviction for burglary, theft, receiving stolen property, breaking and entering, safe cracking, 2 counts of possession of a deadly weapon while under detention. I wasn't aware of this until I looked at the pre-sentence report, because it didn't show up in the discovery, but it also appears that he has prior conviction for possession of drugs and trafficking of drugs. This defendant has had, from what I can tell, he's had 2 prior opportunities at community control. Each time he violated and was ultimately sent to prison. And looking at this case, I realize it is just a 5th-degree felony. However, this is a little different than your typical 5th-degree felony. The defendant was actually operating a vehicle when he struck a school bus head-on US 50 here in Highland County. When the trooper responded and was talking to the defendant about what happened, he gave a far-fetched story about someone chasing him, firing gunshots after him. That was unsubstantiated and likely false. A search of the vehicle following the crash led to the discovery of methamphetamine. When questioned by the officer about the methamphetamine, the defendant claimed that belonged to an ex-girlfriend. So, in looking at the defendant's extensive criminal history, his prior failures on community control, his refusal to take any responsibility for what occurred on the date of this incident, It is the position of the state, this defendant's not amenable to community control and would ask that he be sentenced to return to incarceration. Thank you.
All right, Mr. Colby, on behalf of the defendant.
Thank you, Your Honor. I did submit a sentencing memorandum, and I hope the court had an opportunity to.
Did not, she just submitted it just out today and had time for reading and a full body.
Okay.
It's always a good idea to submit things early.
Well, I think we sent it over on Monday, but nonetheless.
It's file stamped today.
Gotcha. But I did submit a sentencing memorandum, and what is contained there as exhibits are treatment records for Mr. Carnine. He began outpatient treatment through the CAP Health Group in April of 2020 upon his release from prison. He has been engaged continuously in treatment through that program, and I submitted to the court a year's worth of negative drug screens reflecting only his medication, Suboxone program, and Casino marijuana for, so only those substances he has ever tested positive for in his almost 2 years of treatment through the CAP group. And I would point out, he did indicate that he had signed some releases for probation to get those records. I know that it indicated in the pre-sentence report that they had not received those, but he did sign a release for that, and I did provide those to the court for the last year. In addition to that, this occurred last April, and starting in municipal court, he was placed immediately on a reporting bond there with drug screens, and when indicted on the felony charge here, this court also continued that requirement as well as a curfew. He has reported as directed. He has had all negative drug screens and is not only on probation but also in his treatment program, and I think all of those records are available to the court. He does do telehealth visits, group visits, does some mental health counseling through the CAP health group. He has traumatic brain injury from an injury resulting from a I don't know the details of it in 2006, as well as some social anxiety. And I think what has happened is Mr. Carnine has kind of self-medicated because of some of those issues over the years. But again, for 2 years has been very active in his recovery and in his treatment. I did provide, in addition to the treatment records in here, some letters from family. Most significantly, his brother, Jeff Carnine, who is a detective in Hamilton County. He's here, so I know if he would like to address the court would allow that. I provide those just to say that Mr. Carnine comes from a family not that people who enabled him in criminal activity or in drug use, but a supportive family who's do law enforcement that are trying to hold him accountable and have tried to encourage him and support him in his treatment. He has a stable, sober living situation with his parents and has been there since his release from prison. Certainly, if the court would look at his record, there's no question that there's probably no option other than prison for Mr. Carnine. But if the court would take a look at his performance in the last almost year on a reporting probation as well as being actively engaged in treatment, I think he has shown that he is amenable to community control, would be willing to follow many requirements of the court, including continued treatment, including mental health, any kind of house monitored arrest, anything of that nature. He would be willing to apply because he has shown that he can do so. Additionally, I did contact Ms. Sturgill, I think of the drug court program, just to see if she would be willing to assess Mr. Carnine. I think his residency precludes him from participation in that program, whether or not he was otherwise appropriate. I'm not sure if she did complete an assessment that the court received, but I did request that of her, and I know he met with her in that regard. So we just asked the court. He does have 2 young daughters that are 12 and 9 that he sees regularly, and I know his hope is to turn things around and be a good role model to them by maintaining his sobriety and staying out of trouble. And we're asking the court to consider all of those factors and allow Mr. Carnine to continue outpatient treatment and continue to do community control.
All right. Officer Carnine, you wish to speak?
Yes, Your Honor. Where would you like me to
Just
stand?
right there, just,
They remove my master.
record.
May I remove my master?
Yes, ma'am.
Your Honor, my name is Jeff Bonner. I'm a detective with the Forest Park Police Department in Hampton County. This is on the northern side of Hampton County. I'm in my 14th year, about to finish my 14th year as a police officer then. I'd like to read you a letter that I wrote to you. Dear Judge Cost, my name is Detective Jeff Carnine. I'm Jason Carnine's older brother. Like I said, I've been a police officer at the Forest Park Police Department in Hampton County for over 13 years. During my tenure, I served as a patrol officer, undercover narcotics agent for the Hampton County Drug Abuse Reduction Task Force, and currently assigned as a detective. Due to my experience in these roles, I have personally acknowledged the effects of drugs on our community and our state. Jason has struggled with addiction and poor mental health since he was a teenager. This addiction and the results of his addiction have ravaged Jason and our family both emotionally and financially. Due to Jason's history of drug addiction, he served 2 prison sentences totaling almost 8 years. The emotional and financial toll this has put on our parents is beyond measure, which they are present in the courthouse as well. I'm not making excuses for Jason. I'm the one who had to make the terrible decision to turn him in that caused him to go to prison in 2014, in which he was originally sentenced by Claremont County to 4 years while in prison. He was being threatened with prison rape and gang attacking person, which is where the 2 additional charges for weapons under detention came from. Jason doesn't need to see consequences for his actions, but sentencing Jason to prison will once again, at this point in his sobriety journey, will be more detrimental to his recovery than actually helping. I tell you this in an effort to explain that Jason is not just some everyday criminal. Contrary to what the prosecutor states his record indicates. Extending his prison term will do nothing to rehabilitate him, but will do more harm to himself and ultimately the community. His mental health has been a struggle his entire life. Jason has struggled interacting with others in a normal social manner. He struggles and misreads normal social interactions. In the past, this has ultimately developed into Jason self-medicating with illegal drugs. Jason needs mental health treatment that will not happen in prison. Since Jason was arrested, he's been under pretrial supervision, and it is my understanding that he has performed very well in that. Additionally, he has done well at home. I've seen a positive change in him. He spends time with, I also have 2 daughters who are 14 and 9, and my 9-year-old specifically is extremely close to him. He speaks with a counselor on a regular basis and appears to be making positive steps. Prison will not only crush him, but it will set his recovery back even further. Drugs are rampant in prison. He can get them there. And ultimately, Your Honor, if you sentence him to probation, you will have more control for a longer period of time over him to ensure that he is recovering and being a positive member to this state, this community that is sending him to prison. The last in 2014, as much as it killed me, I wanted him to go to prison because I didn't want him to die. That is not my fear today. You will not see him back in front of your courtroom. And the past year, or almost a year, shows that he's amenable to probation, and he will do what needs to be done. And as his attorney stated, he has never tested positive for methamphetamine. He was in a poor relationship, and the breakup created a lot of anxiety and mental health issues in him. And as far-fetched as the story may seem, there's no indication to state that it is false. There's no evidence to state otherwise. As me being a police officer, yes, it does seem far-fetched, but we have no evidence to prove otherwise. I beg mercy of the court to please give him probation. Thank you, Your Honor.
Mr. Carnine, is anything you'd like to say?
Yes, sir. First of all, I'd like to apologize for being here for this incident in whole. I've been stupid a lot of my life, and I paid all the price for it back in, and as it's been stated, you've seen my criminal history. I've done a lot of time, almost 8 years. I've been buying, counting jail time way more than that, 10 plus probably. I'm not that man anymore. That's the first thing I'd like to try to say. I've seen some hard prisons while I was away. I went from a level 2 all the way up to maximum security level 5 Ohio State Pension. Talked to a man that's went a year and a half without seeing his own reflection. 2.5 without human contact. I'm not saying I didn't deserve it. I took a harsh punishment and made me who I am today. I listened to my grandmother die on a long distance phone call in the prison cell. And I'm now on that day, changing my life. I finish out the time any way I can. I'm going to try to survive because it was a fight every day. It was a fight. Prison is extreme. I'm sure you know the circumstances. I've seen the worst of worst behind the walls, and that's why I know before anybody that there's no help for me behind the wall. I've seen discipline as hard as the state can put it that way. I'm trying to learn how to be human again. This incident here, I got out of prison. I told myself I was going to do everything I can to stay right, which I believe I have. Job, medications. I need marijuana for anxiety. I don't want to rely on any harder or prescribed medications just because I struggle with addiction for that. So that's the only thing I can personally rely on. Going the legal route for that has been extremely important for me because it's the only thing I can use, and it's saving. But anywho, I got into a relationship about 4 months when I got released from prison. I moved in with her. That was a mistake. I have lost more sleep over this F5 than I have facing 4 years with, worst cases. Because I don't know what I did wrong in this case. I don't. I am not a meth user. I have no history of using methamphetamine. I am not a meth distributor. From what I've heard after, because the only time I've heard of this meth was through the results that you got, was a microscopic percentage of meth was found in my girlfriend's belongings, luggage that is documented, that from a breakup that had just happened hours before. I tried to get myself out of a bad situation the moment I seen it, and I thought I did. I don't know what I could have done differently that day, but I apologize for the mistakes I made, and I'm sorry for being here. The incidents of the day do sound crazy, but if I had time to explain it, and if you'd like to, I could walk it through step by step of what happened in the events that day that led me to that incident. I was not high on any kind of medication that was not prescribed to me. I have not been high since going back to prison in 2014. The day I stepped out of prison, I got on an addiction treatment program because I am an addict. And throughout my prison sentence, I grew up as a man. I grew in prison, and I realized my faults. I'm an addict. It's in my blood, and so I need to fight that the best way I can. The day I got out of prison that week, I went to addiction treatment, sought out what they thought was right, and I've stuck to that plan since. I've made more progress in my life the past 2 years, and specifically the past year, than I have since I was a teenager. And I beg you to help me continue to build myself in a man in the community. And I've seen 2 of your 3 probation officers, Eric Arizona and the female officer, throughout the 10, 11 months I've now been reporting, and neither one of them can say a bad thing about me for the past year. And for the following previous year before that, I have documented drug screens weekly that also testify that I have been clean throughout the past 2 years on a weekly basis. I don't know what else I could do. I wound up in a bad situation, and I apologize. If given the opportunity, you will never see me again, and I'll be just the most ecstatic person to ever walk out of here on probation that you've ever seen. This has kept me up at night for a year, and I just want to be able to rebuild my life, get this the best way handled for us, and I see probation as being that. I will not mess up, sir. I mean, I promise you, even if you see me one more time, I've been reporting, I'm not going to run anywhere, I'm going to get the job, you have all my addresses, I'm stuck. You know, you can throw the book at me if you see me in front of you, but just give me one chance. I've grown up since you've seen what you're reading in front of you, and my history, that's a long time ago. I'm a 34-year-old man now with a 12-year-old daughter and a 9-year-old daughter. You don't know I'm standing here before you today because I didn't have my heart to tell them that the dad might be leaving me here. And this time I don't know why. But I'm trying to own up to it the best I can, get this over the best way possible, and I seek your blessing, sir, to just continue my mental health care through KAV, continue my treatment. I'm on medication that will cause serious withdrawals for some time. If I'm cuffed up and taken out here today, I take it twice daily, and I do counseling. As a matter of fact, at 5 p.m., by 5 p.m., I have to be at KAV for a urine submission, and my therapy is tonight via telephone at 7 o'clock. So I will continue to do that, and any additional treatment that you require in community service, ankle monitor. I've been on technically house arrest for, I want to say 6 months, if not longer. On top of the probation, that's nearly been a year now. And I haven't wandered once. I give you my word, sir. You will not see me again. I can't see Eric Gardner. I have one bad thing to say about me. I've asked him. I forwarded him all of my treatment paperwork. He has assured me, and right there in front of me, emailed everything and passed everything on about my treatment history to who it needed to be. And I pleaded with him for months to please be here in court, stick your neck out there for me for one time, Eric. You know, I've never really been given a chance. I've seen some hard time for really stealing a bicycle. I know, but I've done a year for that, and I got sent. You never know what, the next day in prison really is not guaranteed. And I've seen it firsthand, and I'm scared to death of it. I can go on and on and on. It's 1 F5. Please, Your Honor, give me one chance to prove that I'm not that man anymore.
All right, thank you. A couple of things. It's interesting to me that you were in Highland County and left the center and crashed into a school bus. Well, there's not really much information about that, so I don't know what was done, but I see here that the vehicle that you were driving belonged to your stepfather, and the officer observed a used hypodermic needle in plain view. If he could see it from outside the vehicle, it's hard for me to believe he couldn't see it from inside. I'll say this, Mr. Arnott, I think you've done reasonably well, but I can still hear the con talk. You are still talking like a con, and blaming on the girlfriend. Terrible situation, but I find it hard to believe that if this is her meth that she claimed, that you would not have known about it being that you would not have known that she was using it. Maybe that's what you're describing. It's a bad situation, but the fact of the matter is that you're in that situation with someone doing drugs, you would seem to me you would obviously know that. So I think this is a problem. Another thing that concerns me is that You have medical marijuana card?
Yes, sir.
Okay. Well, I'm not familiar with KAB, but I can tell you, I run the drug court, and I can tell you that in the drug court community and the treatment community, we think that medical marijuana cards are crack because it's a way to legally self-medicate, like alcohol. We also prohibit people from having alcohol. And quite honestly, the only reason we have medical marijuana in this state, perhaps soon to be recreational, because it's a way to get permit in there. Because the science is studied and studied and studied and still cannot come up with a scientific justification for its medical use. We have lots of anecdotal reports, lots of correlations, but not causation in terms of it being medically beneficial. And what we find in the treatment community and the drug court is that people that are self-medicating are really not dealing with addiction. Now, granted, I don't look at marijuana like it is not cocaine or methamphetamine or heroin or fentanyl, but it's like alcohol. It's legal to get, and the doctors are just selling these things, and they, again, that's why the DEA doesn't license it, and that's why they can't use banks, because it's not recognized yet. And so it's a crutch that you're using that really concerns me. And I know in our treatment providers around here, we don't allow it, and I don't allow it. And so if I put you under control, you're not going to be allowed to use it because it's a crutch. And it's not anybody that's dealing with medical marijuana, using marijuana, medical marijuana. It's just using it because it's the one thing that's legal to use. Legal because the state says that we can sell it for medical marijuana purposes. Quite honestly, I think every time a doctor writes they don't write a script for it, they write an order. And I think it's just ridiculous. They're just doing it because people want to get high and bellow it out or whatever, and illegal. Okay, that being said, you have been clean on everything else. Apparently you were clean at the jail. There's no indication that you were high at the time of this offense. So I'm going to give you a chance here. It's not going to be quite what you want, but I'm going to give it to you as best you're going to get. I'm going to order that you be sentenced to a term of 3 years of community control. Under these conditions, first you're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. Be truthful in all statements you make, as well as any answers you give to the probation department about questions of supervision. You must keep it informed of the residence, place, and employment all times, not change either without prior permission. Not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility nor may communicate with or attempt to communicate with anyone in the inmate and those facilities. You're already multiple times disqualified from purchasing, possessing, and using or having under control the kind of firearm in which you're dangerous ordinance. This is another disqualification. If you have any of those items, that's all you did when you were in prison. Well, I don't think firearm is dead, but if you commit, if you possess any of those, it's another felony violation of the federal state law. You're also prohibited from having any of those items or any other weapons while you're under community control. You're not permitted to purchase, possess, use, have under your control any type of controlled substance, drug abuse, CBD oil, kratom, any variant or analog of any controlled substance that has an effect similar to controlled substance drug abuse. Or any instrument, device, or thing may be used to administer those for credit administration unless you have a legal prescription for that. You must provide a copy of that to your supervising officer within 24 hours of receipt. You're submitted to drug testing when it is directed. May not have medical marijuana. Now, you are not permitted to purchase, possess, use, or have under your control any type of a controlled substance, drug, or any alcohol beverages. Nor may you be in places where the soul will be consumed, even as otherwise law. Again, that's just like marijuana, medical marijuana. It's legal, but it causes problems. You're not to associate with anyone who has criminal records, a member of gang, or other criminal group, or any person who has in the past or in the future before you commit a criminal offense violating these conditions, unless that's approved in writing by your supervising officer. After the date of this order, you may not marry, establish cohabitation, and common law marriage type relationship with another person without written permission. Does report any contact with law enforcement or any arrest, citation, conviction, not later than the next business day after that occurs. Provide your supervised officer financial information records so you're going to pay fines, fees, and costs to be reviewed. You're referred by the probation department for evaluation, settlement, any further treatment, therapy, counseling, training, or other educational programming. You're to submit to that. If any program is recommended, you're to enroll and successfully complete that. You're paid the court costs of that legal time and any arrangements for the court to do that. You'll be ordered to successfully complete the STAR, CBCF, and aftercare program. And you'll be committed to the county jail forthwith and held there until you go to the STAR program. And I think they'll probably get you bed in the next 2 weeks. I have several beds reserved for the next week and the 15th. Now, by being placed on community control rather than being sentenced to prison, you're deemed with consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time, any officer of the probation department. The court will not impose any fine or any driving suspension. This order to pay the court costs is also a substantive order. You don't pay the court bond, you have arrangements to do that payment plan. Then the clerk will collect that from various, include the letter on bank accounts, wages, earnings, and other assets you have. That doesn't collect it. Then could be ordered to be to do service in this county. Be given the credit for each hour you work in an hour rate set by the court, each hour you work, you should have to buy that out until full. Now, in the event that the probation department feels that you're not compliant with these conditions, they will file a written notice of that with the court. You'll be given a copy, and you'll have a hearing, and you'll be entitled to be represented by an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, you'll be sentenced to a term of imprisonment between 6 and 12 months, fine $2,500. That happens once you complete your sentences imposed by the court under the law. The parole authority does have the option, if you choose to use it, to put you under post-release control supervision up to 2 years. If they do that and they determine that you have failed to comply, then they can return you to prison, even though you served the entire term set by the court for a period of up to half of the prison term that is imposed by the court. However, if you could have felony fall under post-release control supervision in this case, then in addition, whatever sentence the judge in the new case imposed upon you, the judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater. If that occurs, that must be served secondly to the sentence in the case. So you'll be remanded, and we'll notify the probation department that, and actually the probation officer suggested this as a part of your conditions, and I think it is good because it's a thinking for change. And I have to say, I see people in here, and I have people in drug court that have done as much time as you have, in some cases even more. It takes a while to shed that, but you build up in prison. I know that people build up a certain way of dealing with things, and certain active behaviors, and preparing themselves because that's what they have to do to survive. But in the real world, it comes across in not a good way. But you what you communicated here today, I see that. And I had that person, I had a cousin who still has that persona. He's been out probably 10 or 12 years. And I had as little to do with him as possible other than funerals or weddings. And, he's I don't think he's ever going to get rid of that swagger. You don't have the swagger, but the story, what I heard, the way you talk, you're still carrying that with you. So that's what CBCF program is designed to do is provide what they call cognitive behavior therapy, thinking for change. And it's focusing more on thinking and the way you are approaching things as opposed to the actual drug treatment because you have one. Other than your medical marijuana, as I did look through all the things you're turning to the file here just while you were talking, and saw all those positive tests for THC, but negative on everything else. And so that's why I'm giving you this chance, because otherwise, with a record like this, you'd already be out of jail in jail clothes. So that's your report, you're remanded in custody, and you're paid out to the jail and all arrangements and information for medicine on. Anything for the council? Thank you.
Thank you, Your Honor.